Welcome. This is The Law Matters. Of course it does. Hi, I'm Debbie Morais, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that may help you decide that you can handle some issues, some matters yourself. If you decide that you wanted to seek outside counsel, our goal, of course, is to help you be better prepared. So will the counsel that you select. As always, our goal is to help you to achieve the best possible results while saving time and money. As always, we want to welcome again and thank Attorney David Bazar from the Bazar & Associates law firm in East Providence, who weighs in with his legal information, his expertise, and his insights on the various topics that we attack. So today we're going to talk about the disputes between landlords and tenants, from repair issues to eviction notices to non-payment of rent. Those are among the many issues that come up and end up sometimes in small claims court. COVID certainly changed the eviction rules. Where does that stand now? What can people actually do about it on either side of the fence? So how do you navigate a dispute when the landlord, or whether you're landlord or tenant, and you're not happy with the way things are going? You want to protect your own interests to the full extent of the law, as you say. How do we end up doing that? I think first, one of the things that people complain about is, I'm not getting my security deposit back. Of course they want. So if you're the tenant, you're ready to leave. Whether you're month to month or whether you had a lease, how do you make sure that you get your security deposit back in full?
Okay, so as we talk about landlord and tenant issues, we always have to make a distinction between residential tenants and commercial tenants. So we'll talk about residential tenants primarily. I think that's what you were focusing in on. So the rule says that when you leave, you have to give your landlord a forwarding address so that he can send you back the deposit. What the landlord is allowed to do is to go back into the apartment and look to see if there's any damages. And if the landlord finds damages and has an amount that it's going to take to fix it, his requirement is then to send you an itemized breakdown of, this is what your deposit was, this is what needed to be fixed, this is how much it cost, this is what I deducted, and this is what you're getting back. There's a time frame, 30 days usually or so, to get that back to you into your hand. And if the landlord doesn't send you back your money and doesn't respond to whatever the damages was and give you an itemized breakdown of what they are, you can then sue for your deposit back. And the statute actually says you can get treble or triple damages for the amount of the deposit.
So let's break this down a little bit. I know you always talk about document everything. So from the time you enter apartment, house, or whatever it is that you've rented, whether it's month to month or you have a 6-month, year-long lease, if you're the tenant, should you be jotting things down that are wrong at the outset? Should you be taking pictures of everything at the outset? And conversely, what about the landlord? Should he be doing or she be doing the same thing so that you have a baseline so that it's not a he said, she said?
Right.
Should you?
So when I move into an apartment, I would take pictures, photograph any damages in particular, and sometimes those are things you want to get fixed anyway. So if they are, you might contact the landlord and say, hey, just so you know, there's this damage to the stove, or there's this damage to the floor or the wall. Would you please fix it? If that's in the lease, that it's the landlord's responsibility. If they don't fix it, it's just something to bear in mind. But what I would also then do is, when I moved out, I would then again take pictures and document the condition of the apartment or whatever, the house, whatever you rented is. And then when you get your letter from the landlord, if there's additional damages that weren't there, you have some evidence that no, the stove was in perfect condition and working order when I left, or the floor had no damage, or the wall, or whatever they're alleging needed to be changed or replaced or fixed. And in your lease, usually it'll say that normal wear and tear is exempted, so just what is normal wear and tear. So if a rug after 5 years isn't in the same condition that it was in, or the carpeting at the time you moved in as when you moved out, you still may not be responsible if it's normal wear and tear. If it's cut up and holes are in it and it's destroyed for other reasons, that's something different. But the best advice is, and this is the same on the other side too for the landlord, take pictures, both when the person moves in and when they move out. That way you've documented what you needed, not only documented it by the bills or whatever it cost you to fix it, but also documented it by showing it needed to be done.
If it came down to a dispute, would that offset the concern that you might have in saying to your landlord, I want to be with you when you do that walkthrough, because you don't know what they might do? I mean, let's assume everybody's sweet and honest,
Right.
but obviously, who knows? Is that your protection? Is that
If it's possible, I would ask that the landlord, hey, can you come over? I'm moving out today. I'd like you to come through with me so you can see the condition I left it in. And you maybe even videotape the walkthrough with the landlord to say, okay, this is the condition as I left, so that you have it documented.
So different states do things differently. Most landlords, as I understand it, want a security deposit, and sometimes they want the first month, sometimes they want the first and the last month's rent. If you're new to the state or new to the area, how do you know what that landlord is likely to be able to charge you? And what's the difference between last month's and how it's used, and security deposit and how it's used?
Okay. So a landlord who's asking for a first month and a last month or security deposit, what they're trying to do is to say, all right, you're new, I don't know you, I want to make sure that I have some protection. So the last month rent, if it's a lease that's on a year-to-year or even month-to-month, whatever you're doing, if you're going to move out, the last month's rent that you paid can be used to pay that last month of rent, as opposed to a security deposit, which you're not supposed to use to apply to rent, because that's supposed to be a security deposit to make sure the condition of the apartment or the house or whatever you're renting is, the premises we'll call it, is in the same condition it was as when you moved in, except for normal wear and tear. And these are all things, if you do have a written lease, that you can spell out in the lease and what's expected and how it's going to work.
Does anybody ever have just an oral agreement these days with residential living arrangements? And is that binding?
Yeah. So sometimes people will move in on a month-to-month basis. The amount of rent that they're paying is usually signified by the acceptance of the landlord of the monthly check and the amount that it's made out in. And you have some rules that are written in statutorily as to what you're entitled to as a tenant and what you're entitled to as a landlord. But any variations or additions to those rules don't apply because there's no written agreement to enforce them. So, for example, if the landlord wanted no pets, and it's not written in, there's no prohibition about having pets in the general statute, so you can have pets. If the landlord doesn't want other people moving in, that's more difficult to enforce. It's almost possible to enforce in a month-to-month with no agreement, whereas you could put in your agreement that I am renting the apartment to you and so, and other than guests for no more than 30 days or whatever it might be, no one else can live in the apartment. There are things like that that can be written in.
Let's follow up on that, David. So what happens if you and one other person are supposed to be renting and suddenly in move 5 other people? If I'm the landlord, what recourse do I have? Can I say, please have them leave or you're out?
Well, if you have a lease, you certainly can. It would be a lease violation. And there's a process. The process for evicting someone on a lease violation is different than it is for non-payment, because what you have to do is you have to give notice of the lease violation, give time to cure or remedy the problem, and then if it's not remedied, then you can file an eviction, which is a longer eviction than the non-payment of rent eviction, which is much usually quicker, COVID and pandemic aside.
So let's touch on that. So during COVID, if you didn't pay your rent, is it pretty safe to say that almost no one was evicted?
Yeah, there was a stay on evictions. Courts weren't hearing evictions, and the ability to get somebody out for non-payment was almost impossible. But just as an aside, as part of the funds that were created as a result of the pandemic and relief funds that were provided to different states, Rhode Island, at least I know, and you've probably seen the ads for it, have a fund for people who fell behind on their rent due to the pandemic, which is a benefit both to the landlord and the tenant because money can be provided to catch rent up. And remember, the landlords during all this period of time, they didn't, if they had a mortgage, they didn't have that forgiven. They still had to pay their bills.
Good point. And we need to protect that landlord too.
Correct.
So, but now it's, well, COVID still prevails, but it's not with the same
It's
kind
opened
of-
up.
Yes, it's opened up. So now are evictions more possible?
Yep.
And let's say as of this taping, it's spring, it's summer, but in other states, and we always say that these laws vary state to state, but in states such as Maine, for example, if this were approaching winter, isn't it, for non-payment at least, very difficult to try to evict? And even though
Right.
it's a long process, it's almost an impossible one?
Every state is different, and that's true. So in what we'll call normal times, there are some states and some reasons why evictions may not be able to go forward. However, right now is a good time, if you're in Rhode Island and you're behind on your rent, to contact that agency that has the money to say, I would like to try to catch this up, and can you help me, and what are my rights? What am I entitled to? What's my landlord entitled to? And I know that for evictions going through court for non-payment, the courts are setting people, setting them aside and saying, look into these things. Sometimes before the pandemic, we would even say to a landlord, okay, let's have them pay something and have a schedule to catch up, and it can be written into the order of the eviction that you're entitled to possession, it's called, when someone's being evicted, but it stayed pending the payment of a certain amounts over certain times.
And so COVID made these kinds of provisions, and there's, I don't know if I would still call them a safety net, but there's a provision in place. If COVID isn't the situation and someone has had problems paying their rent, we know that a landlord can start those proceedings. Maybe we'll talk a little bit later about that process, and I understand that can be kind of difficult at best. Is it likely that a landlord and a tenant could sit together and say, okay, you need to catch up, do 1 month and a half? In other words, keep it entirely out of courts, small claims court, and all the rest, just by writing it down? Is that legitimate? Does that protect the landlord as well as the tenant so that he doesn't get an eviction notice if they've just written it down at the coffee table?
So people can work out their own agreements and details as to what they're willing to do. And for the landlord, getting money is better than having to file an eviction, especially if it's an otherwise good tenant. And for the tenant, obviously, who likes being where they are, they don't want to be evicted. And if there's a rational reason for why things have happened, but we can work it out ourselves, that's always preferable. And yes, you want it in writing, because if you're following the plan that was agreed to, the landlord would be bound by that. So the landlord couldn't turn around and say, oh, you're behind on your rent, so I'm going to evict you. And if you don't follow the plan, the landlord still has the right to evict you for being behind on your rent. So yes, I would always recommend that. But also just remember and bear in mind, if there is the possibility of contacting the state and using the funds that are available, that might also help resolve the eviction.
So COVID kept people from being evicted. Landlords were probably even less likely to go to visit their properties to check in on the circumstance. Are they taking good care of the property or not? So maybe in the case that the tenant isn't taking good care of the property, the landlord now sees that it's a problem. Does that give him more leeway to say, okay, I had to grant slack because of the circumstances. Now you either have to replace that rug in 30 days, that's your cure option, or you're out. Does he have more leverage now, or is he just at a clean slate where you have to start and say, now we see that I've gone and done this quick check, giving you some notice, 2 days or whatever you have to decide on. Does the landlord have more leverage now in making sure that that tenant pays his rent and fixes what needs to be fixed?
Well, I don't know if I'd call it more leverage.
Okay.
I'd call it more leverage maybe in the sense that during the pandemic, you couldn't file an eviction even if you wanted to,
Yes.
for most things, and the courts were very hard to access because of the difficulty of having hearings. However, they did have some. But if you want to call that leverage, then yes, there's leverage because you can go to court now. But the rules are the same. The rules are the rules. So if I am in violation of a written lease agreement, the rules are still that I have to be given notice of the violation, the opportunity to cure the problem before I can be evicted. So the landlord has all the rights the landlord had to say, yes, there is a violation, this is what it is, and you need to fix it.
Okay, and for the tenant, things have been going wrong in the apartment, COVID happened, you couldn't fix this leaky pipe. Maybe that's not terrible, but maybe there's an infestation. That is terrible. What recourse does the tenant have? I think probably one of the most severe is, I'm not paying until you fix that. Has that changed, or what is the recourse that the tenant has?
It's back to what it was. It's the same idea. Not paying until you fix it is always a difficult thing. And if you're going to do something like that, you should open up a separate account to put the money into, so the money's there when the repairs are made and everything's corrected. But I never really advise not to pay, because that's a non-eviction case, and now what are you going to do? If you get in front of a judge and you don't have the money, and your defense is, well, he didn't fix this, the judge isn't going to be too happy about you not having the money available in an escrow account or some other place to say, oh no, I've got the money and I told him to fix it. You might have a more sympathetic ear if you do it that way.
So what are those big stick options other than saying I'm withholding the rent? Could you say, I just can't tolerate whatever this problem is, you haven't fixed it, I did, I'm deducting it from the rent. Do you have that kind of recourse?
Again, if there's a written lease and you have something in there, that's easy, yep. Without that, or without the term in the lease, depending on what the issue is and how severe it is, if it's really a bad issue, your biggest stick, I think, would be to report it to the city or town where you live. There's a housing standard that has to be met, and if it's not being met, they can come out and issue a violation to the homeowner. So that's
And no landlord wants that.
Correct. So that is probably the biggest thing, but that really is for, I think, some significant issues. They're not going to come out because, they're, I'm trying to think of something they wouldn't come out for.
A leaky pipe.
Yeah, probably. The faucet stripping. But for most things that are of some significance, they will.
So I understand that if there's a major problem, the landlord is and should be on the hook to fix it. Mold issues and things that are health problems or dangerous, all of those things seem like they should and have to be taken care of.
With one caveat.
Okay.
If there's a written lease, you can transfer the responsibility to the tenant in certain circumstances.
Okay.
So if you have, well, certainly in a commercial lease situation, but in some situations, if someone is renting a house for a significant length of time and part of the deal is, all right, you're going to do this, but you'll be responsible for these types of things and I'll be responsible for the others, then there can be some shifting of the responsibility.
How and who gets to decide what's considered a major repair? I might think that carpet is a mess and you as the landlord should have taken care of it. You may say that's really not that significant. Who gets to decide that? Is that something that can only be decided in a court?
No, you can decide that up front in your written lease. So you could say that the tenant shall be responsible for all repairs except for major repairs, which will be the landlord's responsibility. And then a well-written lease will define that term. So how are we going to define a major repair? Is it going to be limited to HVAC, heat and air conditioning, ventilation? Is it going to be roof? Is it going to be structural? Or is it going to be an amount? A major repair is anything that costs over X number of dollars.
And so it sounds like, while we've talked about small claims court, meaning we don't need a lawyer, it sounds like it might be wise on the other side to have the lawyer when it comes time to write the contract for all of the intricacies that maybe some savvy tenants might know about, but even the unsuspecting and unaware might or might not know about.
Depending on how complex you want to make it, that's probably a good idea. As far as small claim court goes, just bear in mind that evictions don't really go to small claims court. They go to, in Rhode Island, district court, which does have the small claims component to it, but it's a different calendar.
And how would someone know state to state what court it goes to? What do
you can
look
look on the judiciary website and usually explain what the process is and what the jurisdiction is for each court, which is what the issue is. And one other thing, if you have a corporation or an LLC or something like that that owns the property or is entered into the contract you're dealing with, you may be required to have a lawyer.
You might.
Well, the entity is considered its own individual. So you can't represent someone at a court if you're not the individual, and they're a separate entity, so they aren't you. And if you're not a lawyer, you're practicing law.
Good to know. What's the demand letter when it comes time, for example, that you are complaining because you didn't get all of your security deposit back or something? The onus is on you to provide some evidence. What goes into a demand letter, and how do you draft it? And do we need a lawyer to do it?
So there's a couple of different things that come to mind when you say demand letter. So one demand letter has nothing to do with security deposit, but it's the rent. So the landlord hasn't been paid, and as part of the process, at least in Rhode Island, to get paid, and then if you don't, to go to court for an eviction, is to send a demand letter. It's a certain number of days you have to give the person to pay, but if you don't pay within these number of days, then I have the right to go to court to have you evicted. So that's a demand letter in that instance. I think what you might, go ahead.
So on the security deposit, the landlord didn't give it back to me. I think that I deserve it. I guess I can tell you why I deserve it. I took care of this, this, this. You're challenging it. So the onus is on me to write something that requires evidence. That's not the same as a demand letter, I gather, or is it?
I think about it this differently. I think that the landlord has the onus to send you a letter explaining why you didn't get your security deposit back and what bills were incurred as a result of the damage that you did. And it's their responsibility or burden to prove that this is what was necessary. So if you don't get it back, I would then probably send a letter to the landlord saying, I haven't received my security deposit back. I have not heard from you. Since you haven't complied with the statute to send me my money back within the time frame that it's due to me, please send me 3 times the deposit I left you, or else I will take you to court for the balance that you owe me.
So with what you just said, are you not tipping your hand to that landlord that you are somewhat savvy in knowing that you were entitled to take him to the small claims court and triple the damages, and who knows if there's punitive damages involved?
That is the punitive damages.
Well, yeah. However much it is, at least that's giving the landlord an idea that you know.
Yeah. And by sending the letter
are.
before you have to take the landlord back to court, maybe the landlord will say, yeah, geez, hey, listen, I'll have you sign a release, but I'm just sending you back the security deposit.
So if you haven't checked out of that place yet, and you're still living in the rent, you've finished your lease, you haven't automatically become month to month, or have you, if you have sent another check in and that landlord has deposited? There's something that sounded very peculiar about that, or not peculiar, but something worth exploring, if you would, David.
So what typically happens is whether you're a holdover tenant because the lease expired and you're paying, but the landlord wants you out, or whether you and the landlord have somewhat agreed that you're extending the lease on a month-to-month basis without actually writing a new lease. If you continue to pay and the landlord continues to accept, you've entered into a new agreement, so to speak, I would argue on a month-to-month basis, if that's the frequency with which you pay rent, for these, I would say on the same terms as your agreement always had been.
Good to know. What about retaliation in the sense that someone may not like the fact that the landlord had raised the rent more than what he likes or thinks was fair or whatever, but also has said, well, I know I did complain that you didn't do this, that, or the other thing. Does that give the tenant actually a reason at all to sue because it's retaliation that you have exponentially increased that rent?
Yeah, so the bigger area where you might see that where there's some issues is if you actually are the one who filed the complaint with the city or town about the violations, and as a result of filing that, the landlord then jacks up your rent, and now you can say, wait a minute, you did this because I exercised my right to say that you weren't responding to fix the loose railing or the broken stairs or whatever else it might be, and now this is in retaliation. So there could be something there.
And how does that play out? Would the tenant then not only get to stay, I'm sure that landlord would dearly like to not have that person as a tenant, have someone else. What happens with that tenant? Is he likely to be able to prevail in that kind of situation?
So it'll be interesting, but what would happen, I think, would be the landlord would end up filing an eviction action, and the tenant would counter with, this is retaliation because I did this, this, and this, and then we'd have to wait and see how the judge views all of that.
Okay, and in the brief amount of time that we have left, can you just touch on how a landlord must issue that eviction notice, or the tenant actually has more recourse than he might otherwise imagine, just
Right.
on the way things are
So
done?
that's what I was saying, is the landlord has to give notice of what you're behind in rent. And then you have that, I forget what number of days to cure the rent problem. And then if you don't, the landlord can file the eviction notice, which is a quick hearing date. Now, if it's your first time being behind, you can cure it even when you get to court by paying it. But if it's a multiple situation where they've been brought to court 3 or 4 times or 2 or 3 times and haven't paid and now you're behind again, curing it at that point will be difficult. You have to do it when you get the notice that you're behind.
And one quick thing, apparently if a landlord changes the locks in order to get you out,
You can't do that. Yeah,
could be
that's
in
a
trouble.
constructive eviction. You can't take it on yourself. You have to go to court.
Beware of that.
Yeah.
We hope that this has been helpful to you, whether you are landlord and tenant. We invite you to continue to watch Law Matters. As we say, it matters to you. Thank you for tuning in.